Good afternoon to all of you, and thank you for joining us for this remote webinar today. For those of you who don't know me, I'm Sonal Dashani, member of 25 Bedford Road Chambers, and I'm hosting this webinar on behalf of Chambers, for which Paul Kelleher, Queen's Counsel, is our speaker, and of course I will introduce him shortly. Delighted to see that so many of you can join us today. For those of you who are new to our webinar programme, 25 Bedford Row started this remote webinar programme during lockdown as a means to be a distraction from homeschooling, Joe Wicks and the odd drinking. We then took a short summer break and are back with this, the first in the autumn series. And so for those of you returning, welcome back, good to see you, and thank you for attending today. Our topic today is aptly named Too Little Too Late, and is one that has no doubt been raising emotion amongst our profession since lockdown began, that of custody time limits and the applications to extend them. One such significant custody time limit ruling, which coincided with the new legislation on custody time limits, was heard at Woolwich Crown Court before the much sought after His Honour Judge Raynor. And our speaker today, Paul Kelleher, Queen's Counsel, was instructed leading Leon Lynch in that case, and Paul is going to tell you all about what happened there, that which you couldn't read about in the papers, the inside story. And he'll also help us consider some of the new legislation, what it effectively amounts to. Turning to Paul, he's a member of 25 Bedford Row, highly experienced silk in all areas of serious crime, including terrorism, drug trafficking, fraud and serious offences of violence and sexual abuse. A member of the CBA committee since 2010, he's been heavily involved in the Crown Court digital case system. And for us, he's our technological guru in Chambers. And you'll recall that one of the earlier webinars that we gave was Paul talking to us about the cloud video platform system, which no doubt we are all very familiar with now. He continues to be heavily involved in all other areas of development of the digitisation of the criminal justice system, but today he's going to tell us all about custody time limits and the applications which are arising on an almost daily basis. And without much further ado, I'll hand you over to Paul. Just two matters. The webinar's being recorded as per the email invite, and if you have questions, please feel free to use the chat function throughout. Paul will either deal with them as he's going along if it's an appropriate juncture to deal with them, or I'll make sure that we get through as many of them as possible at the end. Thank you very much.
Thank you, Sol. Thank you very much. It's always slightly intimidating when I get that kind of intro in case my internet goes down or I press the wrong button on my computer or do something that we've all done at some stage or another. But without more ado, I'll crack on, because the blurb on our website naturally begins by trumpeting mine and Leon's amazing victory in the custody time limit extension application on the 8th of September last week at Woolwich, and goes on to say, I'll be analysing the judgment and trying to anticipate the future. But perhaps I should begin with a little context to Judge Raynor's decision in our case, even if it does take some of the lustre off our victory. Now, as many of you will know, with considerably less fanfare, His Honour Judge Raynor had made a similar decision on the 5th of August. It was reported, but not in the same terms as last week's. So by the time of our case, I have to confess, shooting at an open goal. Judge Raynor had decided to up the ante. On the previous Thursday, Leon Lynch of our chambers had gone along on the same case, and Judge Raynor made some very encouraging noises about how the much vaunted recovery plan was not really adequate to meet the crisis. The prosecution then made noises about instructing silk, so I was approached to see if I'd represent the defendant. This is not a silk case. Now, this is partly because I've been making similar submissions in my own cases, that is to say CTL shouldn't be extended as the government hasn't provided any information about when trials were going to happen. And the legislation, that is the CTL legislation, didn't allow for indefinite extensions simply because lack of funds meant that courtrooms weren't available. More of that later. So Leon applied for legal aid for a silk, but the reality was that it's never going to be granted in time for me to prepare for the scheduled hearing the following Tuesday, as the deadline for any skeleton was Monday at 12 midday. I'd already done mine when I got news that His Honour Judge Kinch had refused the application for silk. But we'd received an email from Judge Rayner which enclosed all the circulating first instance decisions extending CTLs, all of which repeat the same mantra, which we're all perhaps familiar with. COVID-19 was an exceptional problem in the face of which the government was and is doing everything humanly possible to get courts open. Therefore, the lack of courtrooms was a good and sufficient reason to extend the CTLs indefinitely. They also drew our attention to two cases. They are the Crown on the application of Rayside and Luton Crown Courts, and the Crown on the application of Macaulay against Coventry Crown Court, both reported in 2012. Now, to a keen legal scholar such as myself, this was very interesting. These were the two main cases I'd been using myself in my submissions. In summary, Rayside said that where a lack of a courtroom was the reason given for a CTL extension being necessary, the court needed to hear evidence on oath about why a courtroom was not available. And Macaulay said this, and I'm going to quote from Macaulay because it's a pretty direct and hard-hitting quote. They said in Macaulay, if despite such careful management, that is of the budget, an application has to be made to extend a CTL in a routine case because the funds by way of allocated sitting days are insufficient to enable the case to be heard within the CTL, then the application must be heard in open courts on the basis of detailed evidence. It's clear from ex parte MacDonald that it is for the prosecution to satisfy the court the need to extend CTLs. It must follow that evidence from the senior management of HMCTS must be provided well in advance of the hearing to the defendant and adduced by the CPS to the court. The judge must then subject the application and the evidence to that rigorous level of scrutiny which is required where a trial is to be delayed and a person confined to prison because of the lack of money to try the case. And then it went on to say, if there were a systemic problem with court availability, and again I quote, the Secretary of State must amend the regulations and seek the approval of Parliament. If that is not done, the court has no option but to apply the present CTL, and HMCTS must find the necessary money or face the prospect of a person who may represent a danger to the public being released pending trial. It's pretty clear stuff. And when have you ever heard a senior member of the HMCTS management being called to court to give evidence about why jury trials have been delayed for so long? In Macaulay, the court quoted from a case called Gibson, which is probably the leading case on CTL extensions, as it was heard back in 2004 and decided by a divisional court presided over by the then Lord Chief Justice. And in Macaulay, they quoted the Lord Chief Justice, who was referring to the availability, or lack of them, of resources in Guildford. And he said this: as has been said on a number of occasions, indiscriminate use of the power to extend the custody time limits would emasculate the parliamentary purpose. As has also been said, and can well be understood, if Parliament willed that these should be the custody time limits, it was for Parliament alone to will and provide the resources to enable courts and judges to achieve those time limits. Parliament has set custody time limits for various obvious reasons. Parliament ultimately is also responsible for the provision of resources by way of judges, recorders, courtrooms and staff to enable cases to be heard within those CTLs. Is it then in a routine case to be regarded as a good and sufficient cause for extending the CTL that it is impossible to hear the case earlier because the resources available to listing officers make it impossible? But of course, the answer was a resounding no. Now, I've been saying this in skeleton arguments and argument orally since May, but every time judges have sent me on my way with the repeated mantra, it's an exceptional situation and everything humanly possible that could be done is being done. And I have refused to take that on trust and have pointed out that there is some sort of conspiracy of silence going on about what was actually being done. Indeed, a section of my skeleton argument was headed, is there sufficient evidence to determine that the unavailability of a court amounts to a good and sufficient cause in this case? In other words, What evidence was there that the MOJ had done everything humanly possible? So in the case last week, I pointed out to Rayner that, firstly, given what the Lord Chief Justice had said in Gibson, I pointed out that the Lord Chancellor appeared to have taken a vow of silence and had said nothing, literally nothing, since the shutdown until July of this year. The only news was the Lord Chief Justice's press release on the 17th of March, which shut down the courts until the 30th of April, in which he said that cases will be kept under review and the position regarding trials will be revisited as circumstances develop and in any event next week. And on the 23rd of March, he issued a press release which said, "This morning, no new trials are to start. Jurors summoned for this week are being asked to remain at home and contact the court they are due to attend. They will only be asked to come in for trials where specific arrangements to ensure safety have been put in place. Efforts to bring existing jury trials to conclusion should continue." That was the 23rd of March, 7 days before the 1 month and 7 days before the 30th of April, which was the date originally set for some sort of resumption. That press release then discussed safety measures that were being introduced, saying, if it is necessary to adjourn trials already underway for a short period, I stress, for a short period, to put those safety measures in place, this must be done. And since then, nothing, not a word, from either the senior judiciary or the MOJ or HMCTS. We all know about the protocol, which was issued on the 27th of March. No one has ever established what its legal power was. In fact, it was simply telling us how CTL applications would be heard and emphasized it contained only rules of practice. And it said in terms, every case must be decided on its own merits. The relevant law is unaffected. It was amended, I think, 2 weeks later, because the first version said during the period that this protocol is in operation, the date for an extension should not be for trial, but for mention of further remand. That was revised 2 weeks later to the extension should be a date that should either be for trial or further remand. Now, was that amendment because by the 7th of April, when it was issued, it was expected trials would resume? Or was it because the original version was plainly subject to judicial review or decisions based upon it? Because the legislation was clearly never designed to just extend CTLs indefinitely. I stress indefinitely, which is what has actually happened. Again, after that protocol, nothing was ever published about what the HMCTS or the MOJ were doing. First news we had was the announcement in July. So nothing in May, nothing in June. An announcement in July about Nightingale courts, but none of them opened till August, and they've had a negligible impact on the growing backlog. All we had was press releases on a weekly basis saying, oh, such and such court has opened, such and such court has opened. And video hearings were introduced to deal with non-jury business. And of course, there were a few show jury trials being conducted to suggest business was being conducted as normal. And consistently, the MOJ would tell the public 90% of courts are now open without telling the public, or indeed confirming to us. That was 90% of court buildings. As far as courtrooms ready for jury trials, we had to really hunt around for any information at all. The only piece of concrete information I've ever seen about steps being taken to make courtrooms jury-friendly with proper social distancing is a spreadsheet that His Honour Judge Rayner disclosed before our hearing. I doubt that any of you have ever seen it. It's an HMCTS document called Screens Schedule. It's dated August. Why so late? Well, you may have heard that courtrooms are being fitted with plastic screens between jurors, etc., so they can be closer than 2 meters apart, but not infect each other. A pretty obvious step, you may think, to have taken back in March when this court's closed. So why has it taken so long? We haven't heard of an international shortage of plexiglass like PPE. I don't know, perhaps there is one. Again, we're not told the reason, but the spreadsheet reveals that the process of evaluating courtrooms for this measure, evaluation didn't even begin until the 16th of July. That evaluation process took about a month. It wasn't completed till mid-August. And that's why the delivery dates on this spreadsheet for these miracles of human ingenuity and modern technology are between late August and late September. Yes, it's taken the government 6 months to plan, supply and install a few plastic screens. If we'd known that, would we have been so easily fobbed off by judges up and down the country telling us, without hearing any evidence about it, without therefore giving the defence any chance to challenge the statement, that everything that could be done, everything humanly possible that could be done, has been done to get trials up and running? Now, I acknowledge this state of affairs isn't up there with nurses, doctors and others dying because the government had run down its stocks of PPE, or to prioritise the Cheltenham Festival over keeping vulnerable old people alive. But it does make you think, doesn't it? So back to Judge Rayner's judgment. It's quite simple, really. It's quite long, but it's fairly simple. I'd submitted to him that it wasn't the lack of a courtroom that could or should amount to a good and sufficient cause to extend a CTL. It was the reason for the lack of one, and he agreed. I was simply parroting what was said in Macaulay and Rayside and others. He accepted, as we all do, that the COVID-19 crisis was unique and unusual, but any judge needed to look at why that made CTL extensions necessary and for how long. In other words, why couldn't trials proceed more than 6 months after the crisis unfolded? He accepted that to decide that he needed to hear evidence, as the law plainly says, and to allow the defence to cross-examine it, as the law plainly says. And yet the prosecution had chosen not to call any. And so he said in his judgment, I agree with the submission of Mr. Kelleher that from the outset of the coronavirus pandemic, sufficient notice was given to the MOJ HMCTS of the potential consequences, and that, to adopt his wording, it has been going on for so long that the delay in bringing cases to trial has become routine. I'm sorry, that's me quoting Rayner quoting me. The fact that the coronavirus health situation is exceptionally went on is not the, quote, be-all and end-all when judges take decisions on applications to extend CTLs. The whole range of other questions which I set out in this ruling must also carefully and thoroughly be addressed. In particular, I agree with Mr. Kelleher's submission that extension should not be granted solely on the basis of the coronavirus pandemic. In circumstances where there is insufficient evidence of what measures MOJ/HMCTS considered and or actually implemented so as to justify the non-availability of a trial date. And he went on to deal with that at great length and in great detail later in his judgment. I should stress, although he quotes me, he didn't need any persuading. He accepted my submissions that the defence had faced a wall of silence from the MOJ about what was really being done. Again, in his judgment, he says, the defence has set out in its skeleton a chronology of relevant dates, see paragraphs 28 to 41. Mr. Kelleher submits that from March to July 2020, there has been, quote, complete silence by the MOJ as to the specific concrete measures, no pun intended, it has implemented, not merely proposed, to resume jury trials. There is some force in that observation, he said. And he concluded that on the available information, not enough had been done to get courts up and running, citing the screen scheduled timetable as an example of the poor and delayed response by the MOJ. So in response to my submissions that the state had a legal duty to provide sufficient funds to try people without undue delay, he posed the rhetorical question, has the state failed to organise its legal systems so as to allow the courts to comply with the requirements of Article 6.1 to ensure trials within a reasonable time of unconvicted defendants? Whether the appropriate test is, quotes, regardless of cost, or even a less requirement of high cost, or even cost proportionate to the exceptional situation, the answer to the question, has the court, says the state failed, was yes. He asked the second rhetorical question, does the evidence now available to me indicate a lack of funding by the MOJ? The answer was yes, he said. And do the new proposed measures announced in the press release of the 6th of September and in the criminal court's recovery plan have a realistic prospect of success in the sense that they will significantly reduce the backlog of outstanding trials for those in custody? No, he said. And he thoroughly eviscerated the government's plans and announcements. He went through them in great detail and explained exactly why they were wholly inadequate. This isn't a broad brush judgment. He dealt with all the detail. And he concluded by saying, MOJ, HMCTS expect to have 250 usable jury trial rooms, quote, by November 2020. This, in my judgment, is too little, too late. The duty on the state to organise legal systems so as to allow the courts, etc., is one that they have failed. So that's why his judgment was described by Clive Coleman of the BBC on the radio that evening as a blistering attack on the government's ability to conduct itself competently in the area of the criminal justice system. Now, there is, of course, a postscript. At the end of his judgment on Tuesday were 3 paragraphs dealing with his status as a judge to hear this application, and the fact that the senior presiding judge had issued a memo suggesting only judges with a full murder ticket should hear them. And he added, individual judges must not be subjected to undue influence, even if slight and well-intentioned. A slightly mysterious and cryptic comment at that stage. The next day, the Wednesday, a case was listed in front of him in which counsel had expected to argue the custody time limits extension. But as it happened, it was only listed that day for mention. I wasn't there, but he announced that although he was the trial judge, a decision had been taken by the senior presiding judge that a High Court judge would be drafted in to hear the CTL extension application, and that he would not or could not. According to those present, his unhappiness was manifest. So the background to his mysterious comments and that rather odd situation was then revealed on Thursday morning when Judge Rayner went public with the stunning allegation that attempts have been made to persuade him not to come to the decision he'd come to in our case. Now, I stress, these are only allegations made by Judge Rayner, although he did publish to the interested parties notes of the conversations he had had and the text of emails he'd received. He didn't sit on Friday, although he had been scheduled to do so, and according to emails I've seen, he did volunteer to come in and sit. The reason why he didn't sit on Friday has, as far as I'm aware, not been made public. So where does that leave us? Firstly, as you probably all know, CTLs for cases involving people remanded after 28th of September will now be 8 months, not 6 months. Now, this is intriguing and important. Given this change in the regulations has been made in the light of the COVID-19 pandemic and in the middle of this crisis in the criminal justice system, it can only mean that as far as the government and indeed Parliament are concerned, anyone remanded after the 28th of September can expect to be tried before the 28th of May. How could a court possibly entertain a CTL extension application next May on the basis there was no court available because of the COVID-19 crisis, when these new regulations have been amended precisely to extend the time limit to one which the government and Parliament consider is a reasonable time limit to cope with the COVID-19 pandemic? Secondly, in the light of Judge Rayner's complaint, are we witnessing a wholesale interference with judicial independence, given that the senior presiding judge in the South Eastern Circuit has merely suggested initially that only judges with a murder ticket should hear CTL extension applications, a ticket that Judge Rayner doesn't hold? Or is it the case that actually, genuinely, every judge in the country agrees with each other and apparently the Lord Chief Justice, and that Judge Rayner is unique in being wrong? Will any other judges adopt submissions similar to the ones I made, that they must hear evidence that justifies why no courtrooms are available before using that as a justification for sending a CTL? The law seems to clearly require them to do so. They can't decided on the basis of something in a protocol that was issued in March and has since been withdrawn as being, quote, out of date? Can they do so on the basis of a press release issued by the Lord Chief Justice and the MOJ on the 6th of September? It would appear not. Rayside and Macaulay are unequivocal. Evidence must be heard on oath and subject to cross-examination. Those cases, by the way, were decided by the President of the Queen's Bench Division at the time. What is the legal status of a direction from an SPJ that a particular judge, in this case Judge Rayner, should not hear a CTL extension application in one of his own cases? Time will tell if that decision is subjected to litigation. And what is the legal status of the memo from the SPJ suggesting, the memo only suggested that only a small cohort of Crown Court judges should be permitted to hear them? I pose these as questions because I frankly concede I don't know the answers. But for those on the inside of the criminal justice system looking out, as opposed to those on the outside looking in, who perhaps don't regard this issue as with the degree of gravity that we do, these are very important and very serious questions that need to be addressed and answered in the not too distant future. So that's all I have to say, subject to answer any questions you may have about the background to our case last week, the judgment and my submissions in it, and indeed the, to put it mildly, unfortunate situation that's arisen at Woolwich Crown Court with His Honour Judge Rayner. Thank you very much. Sonal.
Thank you very much, Paul, for that. It is truly astonishing that we are in 2020 and the sort of judicial interference that Judge Rayner is complaining about is occurring. We are in the UK. To have that sort of interference is perhaps unprecedented. Certainly
sorry to interrupt you. That Judge Rayner alleges occurred.
You're right, quite right. The interference that Judge Rayner alleges occurs, even the allegation thereof perhaps is unprecedented. Certainly I don't recall that sort of allegation having been made. And it would certainly be interesting to know if other judges are prepared to make such allegations and whether or not such interference is more commonly available than that which we thought. Paul, just one thing, I understood that there might be a poll that you might be doing, just to give people a chance to scribble down some questions into the chat function. I thought there was a poll that you might do if you wanted to do it now or towards the end in time.
I'm quite happy to do it. It's not exactly a complicated or sophisticated poll. If Varuna can hear us, perhaps she can put it on the screen. It's simply to ask you if you know the answer to this question. I think I know the answer, but my answer is not necessarily conclusive or definitive. I'm not allowed to vote, obviously. So if you want to click on the box that you think is the right number, we'll hear in due course what the results are.
For those who may have it on audio only, the question being asked is, in how many CTL extensions has it been reported that they have been refused, partly or wholly, on the basis that the government has failed to provide adequate facilities to hear trials? So in how many CTL extension applications has it been reported that they have been refused, partly or wholly, on the basis that the government has failed to provide adequate facilities to hear trials? The options are 1 through 5, which of itself perhaps gives some clue as to the answer to this question. And if you vote now, I think we'll be able to give the results shortly. We'll just give you a few moments to just lodge your answers. As they do so, Paul, certainly some of the experiences that I know I and others who have dealt with CTL applications, particularly at the outset, were facing, and this is right at the start of lockdown, when really we had trials that were meant to have started the week of lockdown commencing, was the argument that this is wholly unprecedented. And the natural response that was being given is, we cannot cope with the capacity needed to do a trial. And I know Paul and I, we spoke about this earlier, but an answer that was immediately given on a case that I had at Worcester Crown Court was, because of the unprecedented situation, I'm minded to extend custody time limits. I raised the question of them needing to have checked whether any other court could facilitate. Now, this was at a time when lockdown was new, only limited courts were dealing with trials or about to. And it's fair to say that the court hadn't even thought to check with other courts, assuming that they wouldn't have capacity. In the end, our case was returned, was adjourned for a short period of time for making those inquiries. And the answer came back, we're very sorry, like we were 6 weeks ago, we still don't have capacity. But certainly that is a trend that I know I and others I've spoken to in chambers have had dealing with CTLs. As I say that, I can see that the answers to the poll are as follows. So answer 1, so only one case was 40%, 2 received 38% of the vote, 3 got 88%, nobody decided that 4 was the right number, and 15% thought that perhaps 5 cases resulted in the ruling as asked. And Paul, you're going to, I hope, reveal what you believe to be the correct answer.
I shall, but first of all, if I can just answer your first question. I think it's only right to say that when, back in March, this all unfolded, everybody was in the same position of not knowing quite how bad it was going to get, how long it was going to take. The knowledge about what steps could properly essentially be taken to mitigate the spread of the virus were actually quite well known, because it had been going on for 3 months at least in Asia and other countries, and indeed in the UK by then. So speaking for myself, and I was entirely sympathetic to the dilemma that all judges and all courts were in. They had to shut them down, and it was difficult to know exactly when they were going to restart. I was making complaint in May, not that my trial wasn't taking place, but my complaint was, and has continued to be, why weren't we being told what was being done? Why did we rock up, as I did frequently, to an application to extend a CTL, to be told on the morning by the judge, oh, this is the situation? Because Judge Rayner disclosed to us this screens spreadsheet I told you about, that's the first, last and only time I've ever been able to say, well, look, if you look at this data, it does look as though people have been dragging their feet. Now, without hearing evidence as to how that decision was arrived at, why it took so long, without hearing evidence about that, it's difficult to be, conclusive or critical. But all of this is taking place against a backdrop of general opinion that the government as a whole has handled the whole crisis very poorly, ranging from the decision to lock down so late, through the lack of provision for hospitals and care homes, through to the chaotic and confusing situation since then, and including mixed messages, to put it politely, coming out from the Prime Minister's own direct associates about how you should and shouldn't behave. And so, speaking for myself again, I've simply become increasingly frustrated over the months. We're now 6 months in, that we're not being told, well, what's been done, if everything humanly possible that could be done has been done. That's really the core of my complaint. Going back to the poll, well, those of you who said 1 clearly have read the newspapers and our publicity, but perhaps not in detail. Those who said 2 have read the material with more care, because you're aware of Rayner's previous judgment. Those who said 3 may have read Judge Rayner's judgment with great care, and those who said 5 must know something I don't. I would have said 3 because in the course of giving judgment, interestingly, Judge Rayner said that he was aware of a similar decision to his own by a Crown Court judge in, I believe, Bolton Crown Court, i.e. a decision to refuse to extend a CTL because of lack of evidence of the proper attempts to get courts up and running. He didn't name the case, he just referred to it. So I would have said 3. Anyone who said 5, who wants to type a message in as to why they think it's more, I'd be delighted to hear from them.
Those participants who are attending today will have custody time limit applications currently ongoing or will no doubt face them in the future. As you say, 8 months versus 6 doesn't really seem like it's going to be enough time to fix the situation that we find ourselves in. So what advice would you give either those instructing us or counsel to what they can do in advance of a custody time limit application to get the evidence if necessary, or what questions should they be asking in order to properly prepare for a custody time limit application now, given Judge Rayner's helpful judgment?
Well, if you want to be really incendiary, you want to do a skeleton argument citing Judge Rayner's judgment, but it is, of course, only a first instance judgment. It's only a persuasive, if that, and there are many more judgments out there which say the opposite. But what I would say is those who are resisting CTL extension applications ought to be saying what the court said in Gibson and Rayside and Macaulay, that if an extension is sought, we need to hear evidence. So if a courtroom's not available, we know why courtrooms are not available, because the courts have all been shut down because of the COVID-19 pandemic. But that isn't the answer to the question. Why is it taking so long to reopen them? What steps have been taken? And if you go back to the European jurisprudence, which is contained in Rayner's judgment, you'll find the cases which suggest that the state has a duty under the law to provide sufficient or proportionate funds to make a criminal justice, or indeed any other court system, function properly within, in these circumstances, the context of custody time limits. Let's not forget that the extension applies to, as I understand it, remands after the 28th of September. So until it comes in, until then, which is only 2 weeks away, all current cases are all still subject to the 6-month time limit.
Yes, I suppose I'm just pre-guessing those of us who've got cases where custody time limits have already been extended based on the old legislation. Certainly, in the cases I have outstanding, the custody ones, I have absolutely no confidence that the court are going to be able to deal with them, either because they're multi-handed cases and how they deal with that. And again, Paul, it's something we discussed earlier that perhaps our attendees would be interested to know, that some courts are dealing with it in order to get round the custody time limits or to avoid pushing trials off into the long grass by forcing the severance of defendants, even against all wishes of the prosecution. So certainly I've heard at Canterbury Crown Court, judges are saying 2 defendants is a maximum. And I think that was your experience, or you'd heard on the grapevine that the Bailey was doing the same. It's 2 defendants, and if it isn't 2 defendants, we will sever the indictment for you.
Yes, I mean, I've only heard this as so many other people have received their news about what the CJS is doing through gossip and information from others. It's pretty mild. It's going to be interesting because the prosecution have always resisted severance, quite properly resisted severance, because it's generally not in the interests of justice if you've got 4 people accused of the same crime, for, except in limited circumstances, for different juries to hear their various explanations. But it appears that's the way we're going. I see Mark has very helpfully written in the chat section the name of the Bolton case decided by His Honour Judge Smith. I would love to see the judgment. I would love to see if he was as outspoken as, and there it is.
Oh, excellent. Thank you very much, Mark.
Outspoken as Judge Rayner. There's a question from Lisa Sonal. Do I think our argument will be hampered if we agree to extensions at the start of lockdown? Well, no, for the reasons that I've kind of hinted at in the course of my address today. Early on, it was perhaps reasonable in the unique circumstances we found ourselves in to take on trust the fact that clearly courts had shut and weren't going to open anytime soon. If you were mathematically minded, you could draw a graph, as it were, with a curve on it illustrating the degree of incredulity with which that claim should be met, beginning with 0 at the beginning and then perhaps growing exponentially as time has gone on. And that's a point that's worth making in an argument, to show that you're a reasonable person. No one is suggesting that these extensions couldn't or shouldn't have been made early on, but in the absence of any current trial date, they should perhaps be reviewed very seriously now. My cases, I'm sorry, tend to be murder. I don't know why I'm sorry, but they tend to be murder cases, which raises a whole new set of problems about can you not extend a CTL in a murder trial. But in cases like the one I did at Woolwich, which is a perfectly ordinary possession with intent to supply case, in my judgment, it's very difficult to justify holding people like that in prison for 12 months or longer awaiting trial, just because the government hasn't managed to install plexiglass screens for 6 months.
Well, particularly given that we have seen the successful instalment of plexiglass screens in most of our supermarkets. So the fact that they've been able to do that quite swiftly and it's been in place for many months does seem to be a bit of either reticence or laziness or a lack of understanding on behalf of the criminal justice system of the extent of the issue at the outset of the pandemic. And perhaps they were just a bit slow to catch on, but there does appear to be, on the face of it, no excuse for not having made more advances than we currently have. Mark, thank you, Mark, has said that he's not sure whether the link will work. If we give an email address, he'll send it to you. Thank you, Mark. What we will do, Mark, is if we can liaise with you, we can get that case off you, and that and Paul, the cases you mentioned, the Gibson, Macaulay cases, we can provide them to you because, of course, it will be helpful to you. Diana Ellis, thank you for your question. She says, in our four-hander at the Bailey, we've been asked by the court to consider severance and give a trial estimate if each case is dealt with separately. The prosecution is obviously opposed. When the issue was raised by the defence at the start of lockdown, she ruled against it. So interesting that her experience at the Bailey appears to be one that's changing with time, but at the start of lockdown, the court was against it. And Diane, I don't know whether the position now is that they are more minded to sever, given the circumstances that we now find ourselves in. I don't know if there are any other questions.
There's a comment from Nisa saying, I can't seem to see what's being typed in the chat box by other attendees, and they include their email address. I'm not sure why.
No,
I don't know whether at the bottom of my chat box it says to all panelists. So it may be you can select that, or to all panelists and attendees. So if you type a message in, on the address field, you can select who you send it to. And then the second option is to all panelists and attendees. The first option is all panelists, which is probably why we're seeing them all.
Perhaps. Well, worry not. We will make sure, because we will have all of your email addresses, because we will have sent the Zoom link out to you. So we will ensure that the relevant links to the cases are sent to you after today's webinar. Yes, and I think that's just being confirmed, but we can definitely do that after today's webinar. And looking at that, we are now approaching 10 to 6. So unless there are any other questions, I'm just going to deal with Diana Ellis again. Judge Hidd at the Bailey said that if the parties can't agree severance of a five-handed attempt murder, he will take the decision on how to sever. So there you go. That appears to coincide, Paul, with your my current experience that the judges are being quite hands-on in that approach.
Yeah, I've just copied and pasted the link to the Bolton judgment that was kindly provided by Mark previously, just to the panelists.
Lovely. Well, if the link
I see there's a request from Kate Gould. It would be great to have a copy of Rayner's ruling. Yeah, that will be. Where will that be on our website, Sonal?
We will, in all likelihood, we will send an email reminder, but there will be a link on the email that you receive to our website where all of the documents will have been uploaded together with the recording of today's webinar.
Okay, good.
Well, thank you very much, Paul. Thank you so much for a really interesting and
just one last question.
Oh, yes, I can see.
From Mark again. If it does simply come down to a question of funds, what is in our power to do as legal personnel and the general public to ensure moving forward that the necessary funds are provided to HMCTS? Well, Mark, you put your finger on it. This is why it's such a hot potato and why Judge Rayner has potentially got in so much trouble. It's frankly political. It's as simple as that. What's interesting is in Macaulay and other cases earlier, The courts quite clearly said it's not for us to get into the political sphere. We just apply the law. The law says people must be tried in good time. If they can't be because the executive fails to provide the funds, that's not our problem. We just apply the law. And that's where we're at. I'm suggesting people don't have to get political. They can just rely upon the law, which is that a court needs to hear evidence on oath from the prosecution to justify extending a CTL and not take it on trust. Sorry, it's on.
Agreed. Thank you. And Paul, thank you again for a really interesting webinar topic. For all of us, it's been really insightful, in fact, as the sort of arguments that we should be putting forward, the sort of questions we should be asking. And it will be interesting to see how the next few weeks and months pan out. To all of our attendees, thank you very much for attending today, notwithstanding the fact that we are it's a remote hearing. It is your time, and we're very grateful that you attended today. We will send a link to those documents in the next day or so, so you will have them, and we will send you details of our next webinar in our series. So thank you very much, and we will call this webinar to an end. Thank you.